Hello everyone. Today we are going to discuss the definition part in this Industrial Dispute Act, and in this we are going to discuss all the important definitions which will help us to understand Industrial Dispute Act, because all these definitions will come again and again in this Industrial Dispute Act 1947. So it is very important to know all these definitions. So let us start with this with the definition part of this video. So let us start with section 1. It says short title, extent and commencement. This act may be called Industrial Dispute Act 1947, and it extends to the whole of India, right? It has got whole India operation. It extends to the whole of India. It shall come into force on the first day of April 1947, right? Now let us start with the definition part. Section 2. Section 2, in this act, unless there is anything repugnant in the subject or context, right? Which is unless there is anything repugnant in the subject or context, right? Now let us start with section 2, clause A. What do we mean by appropriate government, right? So appropriate government means in relation to any industrial dispute where there is any it means in relation to any industrial dispute concerning any industry carried on by or under the authority of the central government or by a railway company, or concerning any such controlled industry as may be specified in this behalf by the central government, or in relation to an industrial dispute concerning a dock labor board established under section 5A of the Dock Workers Regulation of Employment Act 1948, or the Industrial Finance Corporation of India Limited formed and registered under the Companies Act 1957, or the Employees State Insurance Corporation established under section 3 of the Employees State Insurance Act 1948, right? Let's move further. Or the Board of Trustees constituted under section 3A of the Coal Mines Provident Fund and Miscellaneous Provision Act 1948, or the Central Board of Trustees and the State Board of Trustees constituted under section 5A and section 5B respectively of the Employees Provident Fund and Miscellaneous Provision Act 1952, or the Life Insurance Corporation of India established under section 3 of the Life Insurance Corporation Act 1956, the Oil and Natural Gas Corporation Limited registered under the Companies Act 1956, or the Deposit Insurance and Credit Guarantee Corporation established under section 3 of the Deposit Insurance and Credit Guarantee Corporation Act 1961, or the Central Warehousing Corporation established under section 3 of the Warehousing Corporation Act 1956, or the Unit Trust of India established under section 3 of the Unit Trust of India Act, or the Food Corporation of India established under the section 3, or a board of management established for 2 or more contiguous state under section 16 of the Food Corporation Act 1964, or the Airport Authority of India constituted under section 3 of the Airport Authority of India Act 1994, or a regional rural bank established under section 3 of the Regional Rural Bank Act 1976, or the Export Credit and Guarantee Corporation Limited, or the Industrial Reconstruction Bank of India Limited, the National Housing Bank established under section 4 of the National Housing Bank Act 1987, or an air transport service, or a banking or an insurance company, a mine or an oil field, a cantonment board or a major board, the central government, right? So these are the things which may be called appropriate government, right? So it says in relation to industrial dispute concerning any industry which is carried on or by under the authority of central government, right? Or by railway company. So these are the things which are called appropriate government, right? Let's move further. In relation to any other industrial dispute, the state comes in relation to any other industrial dispute, that will be the state government, right? Else the upper part, the upper thing which we have discussed, so there all those things will be appropriate government, right? In relation to industrial dispute. Okay, let's move further. Section 2, clause Aa, arbitrator includes an employer. Section 2, clause Aa, average pay. It means average pay means the average of the wages payable to a workman. So it is the average of the wages payable to a workman. How it is calculated, let's see. In the case of monthly and paid workmen, right, in the three complete calendar months. So there should be 3 complete calendar months. This next situation is the The next category, in the case of weekly paid workmen, in the 4 complete weeks. In the case of daily paid workmen, in 12 full working days preceding the date on which the average pay becomes payable, right? If the workman had worked for 3 complete calendar months, or 4 complete weeks, or 12 full working days, as the case may be, right? So these are the conditions, right? These are the 3 different categories: 3 complete calendar months, 4 complete weeks, or 12 full working days, right? As the case may be. And where such calculation cannot be made, where this calculation is not possible to make, the average pay shall be calculated as the average of the wages payable to a workman during the period he actually worked. So where he has actually worked, so it will be calculated on the basis of that, right? Now let's move further. Section 2, clause B. What do we mean by award? Award means an interim or final determination. It means an interim or final determination of any industrial dispute, right? Or of any question relating thereto by labor codes, which is determined by labor code, industrial tribunal, or national industrial tribunal, and includes an arbitration award made under section 10A, right? Let's move further. Section 2, clause BB. What do we mean by banking company? Banking company means a banking company as defined in section 5 of the Banking Companies Act 1949, having branches or other establishment in more than one state. So having branches or other established in more than one state, and includes the Export Import Bank of India, even that will be banking company, the Industrial Reconstruction Bank of India, right? Even that will be banking company. Let's move further. The Small Industrial Development Bank of India, established under the section 3 of the Small Industries Development Bank of India Act 1989. The Reserve Bank of India, the State Bank of India, a corresponding new bank constituted under section 3 of the Banking Companies Acquisition and Transfer of Undertaking Act 1970, right? A corresponding new bank constituted under section 3 of the Banking Companies Acquisition Transfer of Undertaking, and any subsidiary bank as defined in the State Bank of India subsidiary Banks Act 1959. So these all will be called banking company. Let's move further. Section 2, clause C. Board means a board of conciliation constituted under this act, right? Section 2, clause CC. Closure means the permanent closing down of a place of employment or part thereof, right? Now section 2, clause D, it says conciliation officer. It means a conciliation officer appointed under this act. Section 2, clause D, conciliation proceeding means any proceeding held by a conciliation officer or board under this act, right? So that will be conciliation proceeding. Control industry means any industry, the control of which by the union has been declared. The control of which by the union, by the union has been declared by any central act to be expedient in public. So that should be expedient in public. So that should be expedient in public interest, right? By any central act to be expedient in public interest. Let's move further. Section 2, clause G. It means what do we mean by executive? In relation to a trade union means the body by whatever name called to which the management of the affairs of the trade union is entrusted. It is the management of the affairs of the trade union is entrusted, right? So it means in relation, it is relating to trade union, means the body by whatever. So there may be a body by whatever name to which the management of the affairs of the trade union is entrusted, right? So now let's move further. It's section 2, clause I. Section 2, clause G, as we have said, executive in relation to a trade union. So that is in relation to there should be a trade union, means the body by whatever. So the trade union may be having any name called to which the management of the affairs of the trade union is entrusted. So that will be executive, right? A person shall be deemed to be independent for the purpose of his appointment as the chairman or other members of board as per section 2, clause I. A person shall be deemed to be independent for the purpose of his appointment as chairman or other members of board, court, or tribunal if he is unconnected with the industrial dispute. So he should be unconnected, right, to the with the industrial dispute referred to such board, court, or tribunal, or with any industry directly affected by such dispute, right? Provided that no person shall cease to be independent by reason only of the fact that he is shareholder of an incorporated company. Even if he is shareholder of an incorporated company which is connected with or likely to be affected by such industrial dispute, but in such case he shall disclose the appropriate government the nature and the extent of the share held by him in such company. So if he discloses, then he will not be deemed connected, then he will then he will be deemed that he is unconnected with the industrial dispute, right? Let's move further. Section 2 clause J. Industry means any business, trade, undertaking, manufacturing or calling of employers, and includes any calling, service, employment, handicraft or industrial occupation or avocation of workmen, right? So it is means any business, trade, undertaking, manufacturing, production or calling of employers, and includes any calling, service, employment, handicraft, industrial, which has got the industrial occupations, so that all will be industry, right? Let's move further. Section 2 clause K. Industrial dispute means any dispute or difference between employers and employers. So it may be a dispute maybe between employers and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment. So that should be connected with the employment or non-employment, or the terms of employment, or with connection, or with the connection of labor or labor of any person, right? Let's move further. Section 2 clause A. Industrial establishment or undertaking means an establishment or undertaking in which any industry is carried on. It means this industrial establishment or undertaking, this industrial establishment or undertaking means an establishment or undertaking in which any industry is carried on. So in the establishment there should be any industry which is being carried on, right? Provided the proviso says provided that where several activities are carried on in an establishment or undertaking, only one or some of such activities is or are an industry or industries then, right? So it says where several activities are, where there are several activities which are being carried on, right, in an establishment, only one or some of such activities are an industry. So there, on the basis of separation, we can see if we could separate that, so that will be called an industry. Let's see how it can be done. As per the clause A, right, it is a subclause A, right? Section 2 clause KA, subclause A. If any unit of such establishment or undertaking carrying on any activity, being an industry, is severable from the other, which can be separated from the other unit or unit of such establishment or undertaking, such unit shall be deemed to be separate industrial establishment, right? So that will be deemed to be separate industrial establishment or undertaking, right? Now let's move further. The subclause, it is section 2 clause KA, subclause B. If the predominant activity, if there is any predominant activity or each of the predominant activity, right, and or each of the predominant activity carried on in such establishment, which is being carried on in such establishment or undertaking or unit thereof, is an industry, and the other activity or each of the other activities carried on in such establishment or undertaking or unit thereof is not severable, so which cannot be separated from and is for the purpose of carrying on, aiding the carrying on, so which aids aiding the carry on such predominant activity, right, or activities, thus entire establishment. So in that case, which cannot be separated, the entire establishment or undertaking, as the case may be, unit thereof shall be deemed to be industrial establishment. So where it cannot be separated, the predominant activity, right, it cannot be separated, so all that thing will be deemed, it will be deemed industrial establishment, right? Okay, now let's move further. That will be deemed to be an industrial establishment or undertaking. Now let's move further. Section 2 clause KK. Insurance company means an insurance company as defined in section 2 of the Insurance Act 1938, having branches or other establishment in more than one state, right? So it means an insurance company as which is defined in section 2 of the Insurance Act, having branches or other establishment in more than one state. Let's move further. Section 2 clause KKA, Khadi has the meaning assigned to it in clause D of section 2 of Khadi and Village Industries Commission Act, right? Section 2 clause KKB, labor code means a labor code constituted under section 7. Section 2 clause KKK, layoff with its grammatical variation and cognate expression means the failure, refusal or inability of an employer on account of shortage. So it is the failure, refusal or inability of an employer on account of shortage of coal, power or raw material, or accumulation of stock, or the breakdown of machinery, or a natural calamity, or for any other unconnected reason to give employment to workman whose name is borne on the muster rolls his industrial establishment who has not been retrenched. So that person should not be retrenched, right? So layoff is basically primarily because of on account of shortage of coal, power, raw material, right? Accumulation of stock, breakdown of machinery. So these are the causes because of which a layoff can be done, and that should not be, and has not there the workman has not been retrenched, right? So where the workman has not been retrenched, and there is failure, refusal or inability of an employer on account of shortage of coal, right? So these are the conditions already given. So let us see what does the explanation say. Every workman whose name is borne on the muster roll of the industrial establishment and who permits himself for work at the establishment at the time appointed for the purpose during normal working hours, right? So it says every workman whose name is already on the muster rolls of the industrial establishment, right? And he has presented himself for work at the establishment at the time appointed for the purpose during normal work. So during normal working hours, the worker has presented himself, right, for the work during normal working hours on any day, and is not given employment, and the employment has not been given by the employer within 2 hours of his so presenting. So within 2 hours of his presenting, if the employer does not provide him the work, shall be deemed to have been laid off, right? For that, within the meaning of this clause, within 2 hours, the 2 hours clause is there, provided that if the workman, instead of being given employment at the commencement of any shift or for any day, is asked to present himself for the purpose during the second half of the shift. So if he has been asked if he has been asked to present himself for the second half of the day, right? The second, not first half, second half of the day, second half of the shift for the day, and given employment, then he shall be deemed to have been laid off only for the one half of the day, right? So it is very clear, right, from the definition itself, right, that the second half, right, if he has been asked to present himself for the second half, so he will be deemed he will be deemed laid off for the one half of that day, right? Let's move further. Provided further that if he is not given any such employment even after so presenting himself, he shall not be deemed to have been laid off for the second half of the shift for the day, and he shall be entitled to full basic wages and dearness allowance for that part of the day. It means even if it means provided further that if he is not given any such employment even after so presenting himself, it means he has presented himself after being asked, and if after that he is not given any work there, right? So he shall not be deemed to have been laid off. So he shall not be deemed to have laid off for the second half. So I mean, for the second half, he shall not be deemed. He shall not be deemed to have been laid off, right, for the second half of the shift for the day, and shall be entitled to. So there he shall be entitled to full basic wages and dinners allowance for that part of the day, right, for that particular part. Okay. Section 2 clause L, lockout means a temporary closing of a place for employment, right, or suspension of work. It means temporary closing of a place, suspension of work, or the refusal by an employer to continue to employ any number of persons employed by him, right? So lockout, it is a temporary closing of a place of employment, okay, or suspension of work, or the refusal by, so there is refusal by the employer to continue to employ any number of employees employed by him, right? So that this is what do we mean by lockout. So it is lockout means temporary closing of place, right, or suspension of work. So let's move further. Section 2 clause LA, major port. Major port means a port that as defined in clause 8 of section 3 of the Indian Ports Act. Section 2 clause Ll.B. mine means a mine as defined under defined in clause J of subsection 1 of section 2 of the Mines Act. National Tribunal means National Tribunal section 2 clause L section National Tribunal means section 2 clause L National Tribunal means a national tribunal constituted under section 7B. Section 2 clause L officer bearer in relation to a trade union includes. So what do we mean by officer bearer? Who is office bearer in relation to trade? If there is any trade union, includes any member of the executive thereof, but does not include an auditor. So auditor is not deemed to be officer bearer. It's section 2 clause M. Prescribed means prescribed by rules made under this act, right? Let's move further. What do we mean of public utility? Public utility service. Public utility service means any railway service or any transport service for the carriage of passenger or goods by air, any service, or in connection with the working of any major port or dock, right? So public utility service means any railway service. Any railway service will be public utility. Any transport service will be mean public utility service, right? Any section of let's move further. Any section of any section of any industrial establishment on the working of which the safety of the establishment of the workmen employed therein depends, right? So in any section of the industrial establishment on the working of which the safety of the establishment or workmen employed therein depends, right? So that will be also called the public utility service, where the safety of the establishment working therein depends. Okay, any postal, telegraph, telephone service, any industry which supplies power, light, or water to the public, even that will be public utility service. And the section 2 clause N subclause 5, any system of conveyance and sanitation, even that will be deemed public utility service. Any industry specified in the first schedule which the appropriate government may, if satisfied that public emergency or public interest so requires, if there is any public emergency or public interest so requires, by notification in the official gazette declared to be public utility service, that is in the hand of appropriate government, right, for the purpose of this act for such period as may be specified in the notification. So that depends on the discretion of the appropriate government, right? So it may declare so, provided that the period so specified shall not in the first instance exceed 6 months. So it will initially it will be for 6 months, but may by a like notification be extended from time to time. But may by a like notification, it may be at the discretion of the appropriate government, it may be extended from time to time by not period exceeding 6 months at any one time. So it means at one go it may not it will not exceed 6 months. If in the opinion of the appropriate government, public emergency or public interest requires such extension, right? Let's move further. Public emergency or public interest requires such if in the public it says at any one time, if in the opinion of the appropriate government, public emergency or public interest requires such extension, right? Let's move further. Section 2 clause O, it means a railway company, as defined in section 3 of the Indian Railways Act 1890. Section 2 clause OO, right? Retrenchment means the termination by the employer of the service of workmen for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but does not include. So retrenchment means there is a termination by the employer of the service of workmen, right, for any reason whatsoever. So otherwise than so there should not be any punishment inflicted by way of disciplinary action, right? But it does not include the following categories: voluntary retirement of the workman, if there is voluntary retirement by the workman itself; retirement of the workman on reaching the age of superannuation, if there is superannuation, if the contract of employment between the employer and the workman concerned contains the stipulation in that behalf, right? So there is a stipulation in the contract itself. Termination of the service of the workman as a result of the on renewal of the contract of employment between the employer and the workman concerned on its expiry of such contract being terminated under stipulation in that behalf contract therein, right? So termination of the service of the workman, so they as a result of non-renewal of the contract, so there is no there is non-renewal of the contract of the employment between the employer, right, and the workman concerned on its expiry. So there is expiry of the contract on such being terminated, such stipulation. So even that will not be called retrenchment. Termination of the service of workman on the ground of continued ill health. So the health of the workman is not good. So on that basis, it will not be deemed retrenchment, right? Section 2 clause P, settlement means a settlement arrived at in the course of conciliation. So in the course of conciliation, there is a settlement agreement has been arrived proceeding, and includes a written agreement between the employer and the workman arrived at otherwise than in the course of conciliation. Otherwise than in the course of conciliation proceeding. It is otherwise than in the course of conciliation proceeding, where such agreement has been signed by the parties, and that agreement has been signed by the parties, right, thereto in such manner as may be prescribed, and copy thereof has been sent to an officer authorized in this behalf, the appropriate government, and the note behalf by the appropriate government and the conciliation officer, right? So settlement means the settlement which has been arrived in the course of conciliation, right, and it includes there is a written agreement between, so it includes also written agreement between the employer and workman, arrived at otherwise done in course of conciliation. So it says otherwise done in course of conciliation proceeding where such agreement has been signed by the parties thereto in such manner as may be prescribed, and a copy thereof has been sent to an officer authorized in this behalf by the appropriate government and the conciliation officer. Right? Let's move further. What do we mean by strike? Strike means a cessation of work. If there is a cessation of work by a body of persons employed in any industry acting, right? So strike, there is a cessation of work by body of persons employed in any industry acting in combination. So that is in combination or concerted. So there is concerted refusal or refusal under a common. So there is a common understanding of refusal or of any number of persons or any number of persons who have been so employed to continue to work or to accept employment, right? Let's move further. Section 2, clause QQ. Trade union means a trade union registered under Trade Unions Act 1926, right? And what do we mean? What do we mean by tribunal? Section 2, clause R. Tribunal means an industrial tribunal constituted under Section 7A and includes an industrial tribunal constituted before 10th day of March 1957, right? Section 2, clause RA. Unfair labor practice. It means any of the practice specified in the 5th schedule. So any of the practice which is specified in the 5th schedule of the act, so that will be unfair labor practice. Unfair labor practice. Okay. Section 2, clause RB. Village industries has the same meaning assigned to it in clause H of the section 2 of the Khadi and Village Industries Commission Act 1956. Section 2, clause RR. Wages means all remuneration capable of being expressed in terms of money, right? So that should be in terms of money, which would, if the term of employment expressed or implied were fulfilled, be payable to. So that if the term of employment expressed or implied were fulfilled, be payable to workmen in respect of employment or of work done in such employment, right? And it also includes such allowances include it includes dearness allowance, as the workman is for the time being entitled to the value of any house accommodation, if there is any there is any value of any house accommodation or supply of light, water, medical attendance or other amenity of a service or concession, supply food, grains, other articles, even that will be included in wages, right? Let's move further. But it will not include any bonus. The wages does not include bonus, any contribution paid or payable by employer to any pension fund or provident fund or for the benefit of the workmen under any law for the time being in force, right? So it does not include these. Any gratuity payable on termination of service. So if there is any gratuity payable on termination of service, even that will not be called wages. Section 2, as per Section 2, clause S, workman means any person including an apprentice employed in any industry. So it means any person including even an apprentice will be called workman employed in any industry to do any manual work, any manual, unskilled, skilled, technical, operational, clerical, supervisory work for hire, reward, whether the terms of the employment be express or implied. So whether the terms of the employment be expressed or implied, and for the purposes of any proceeding under this act in relation to industrial dispute. So if there is an industrial dispute, so these categories of people will be called workmen. Include any such person who has been dismissed, or even that person will be included who has been dismissed, discharged, retrenched in connection with or as a consequence of that dispute, or whose dismissal, discharge or retrenchment has led to, or whose dismissal, discharge, retrenchment has led to that dispute, but does not include such person. But it does not include these following people: who is subject to the Air Force Act 1950, Army Act 1950 or the Navy Act 1957, right? Who is employed in the police service or officer of this employee of a prison who is employed mainly in managerial or administrative capacity, even that will not be called workman. Let's move further. Who being employed in a supervisory capacity draws wages exceeding 1,600 rupees per mention or so if the wages who it says who being employed in supervisory capacity, that he has got the supervisory capacity, draws wages exceeding 1,600, and his wages include his wages are exceeding 1,600 rupees per mention, right? Or exercises either by the nature of the duties attached to the office or by reason of powers vested to him, function mainly of managerial. So if there is any managerial functions mainly of managerial nature, so that will not be called workman, right? right? Section 2A, it talks about dismissal, etc. So dismissal, etc. of an individual workman to be deemed to be an industrial dispute. So if there is any dismissal of an individual workman, even that will be deemed industrial dispute, right? Where any employer discharges, dismisses, retrenches, or otherwise terminates the service of an individual workman, any dispute or difference between that workman. So if there is any dispute between that workman, any dispute or difference between that workman and his employer connected with or arising out of such dispute, dismissal, retrenchment, or termination. So if there is any difference between the workman and employer, right, that is connected and his employer connected with, and that is arising out of such discharge, dismissal, retrenchment, or termination, it shall be deemed to be an industrial dispute, notwithstanding that it is not going to notwithstanding that no other workman or nor any union of worker is party to the dispute. Even if no other workman nor any union of workmen is party to the dispute, it says even if no other workman nor any union of workmen is party to the dispute, still it will be called dismissal, right? Okay, so as per section 2 clause A of the it is as section 2 clause A, dismissal, etc. Okay, so it is dismissal, etc. of an individual workman to be deemed to be an industrial dispute. So even so, there as at the last part says, even if no other workman nor any union of a workman is party to the dispute, still it will be called dismissal, and it will be deemed to be that will be deemed to be an industrial dispute, right? So this is as said, no other workman or nor any union of the workmen is but even if no other workman nor any union of the workmen is party to the dispute, still it will be called industrial dispute, right? So with this we have come to the end of this. So we have already understood what do we mean by dismissal, right, etc. And that will be this dismissal also, it will be deemed to be an industrial dispute. So with this we have come to the end of this topic. Thank you very much.